public. Just a reminder to please, before the end of today, sign into today's sheet up front for the attendance. With that being said, we have a couple items on today's agenda. The first item is the contract ratification for Pristine Image Amendment. Director Delaney.
This is actually the same amendment that you saw at our last board meeting. We had an error in the amendment that we brought to the board, so we're just bringing it to you again. The first one did not have the date that the contract was, the term of the contract. It didn't say what the extension was. We increased the amount, we didn't increase the time, and so this one actually does both. And so it's the exact same thing as last week. And Pristine Image is our contract for cleaning services out at the service center.
Are there any questions by members of the board? Sorry, I'm dealing with allergies, so I'll try to just talk this out as loud as I can, just at that time of the year. Are there any questions by members of the board? If not, I would entertain a motion.
So moved.
Second.
All those in favor say aye.
Aye.
All right, amendment has been moved. Next item on the agenda is a petition challenge. Director Delaney.
Thank you. Candidate John T. Schmitz filed his CAN 44, which are all of the petitions, to run as an independent candidate on November's ballot for the office of Mayor of Indianapolis. He filed his CAN 45, which is the acknowledgement that you're filing all the petitions. That's essentially your candidate filing form. It is CAN 12, which is your statement of economic interest. Again, this is all to run for the office of mayor as an independent candidate. PR reviews all of the CAN 44 petitions and found that he did not have enough valid or certified signatures to meet the goal that's required. And so Mr. Schmitz is challenging that on the state form, which is called a CAN 1, is a challenge, candidate challenge. And that's one of the boxes that you can check, is challenging the petition signature review process. And he did file that with our office as well as the supporting documentation. And so that is what the board is here for today.
Are there any preliminary questions by the board members for Director Delaney? At this point, we will have council start. Will you explain the procedures and process for today's hearing specific to the CAN 1 challenge?
The Schmitz candidate challenge has been called. This hearing has begun. I am Mindy Westrick, attorney to the board, with counsel from Corporation Counsel David Lichtenberg. The board has received CAN 1, CAN 44, CAN 45, CAN 12, 3 certification letters from VR, and the voter registration petition process standard operating procedures. The burden is that the presumption is that voter registration is correct, and the burden is on Schmitz to prove that voter registration is wrong in their review of the petitions counted to be a candidate for the office of mayor. The challenger will be recognized first. The challenger or the challenger's representative may present their case for no more than 5 minutes unless the board votes to allow for additional time to the presenter. Board members may ask questions during the presentation, but time spent answering these questions will not count against the presenter's time. The election board staff or council may signal the chair when the presenter's time is up. If the presenter offers additional documents or other physical evidence not previously received by the board, the documents must be provided to the election board staff to preserve the record. Voter registration staff or an authorized representative will be recognized following the presentation by the challenger. Voter registration may present their case for the same amount of time allotted to the challenger unless the board votes to allow additional time for voter registration. Following the presentation for voter registration, the challenger will have a 5-minute rebuttal period. Unless the board votes to allow additional time, the rebuttal must be limited to the issues regarding statements made by the presenter. It is common for the board to make a decision immediately following the presentation, or they can take the hearing under advisement and make a decision at a later
you all received 3 certification letters, but you actually have 4. So I just want to make sure that we're clear for the record.
Any questions from the board specific to the procedures for today's hearing? No.
With that, the challenger or his representative may begin.
Thank you. My name's Mark Small and I represent Mr. Schmitz. I appreciate the opportunity to address you this morning. There's nothing that's more important in our country than the right to vote and the right of candidates to get access to the ballots, to be listed as candidates. Very reasonably, we have statutes in this state that require certain things of candidates if they're going to access the ballot and if they're not members of one of the 2 major political parties, independent candidates. Mr. Schmitz is an independent candidate. There are several categories of voters' signatures that were rejected based upon their not in compliance with requirements of the statute. And I would suggest, as I believe I point out in the attachment A, that these are arbitrary and capricious because they're contradictory. The biggest category is that the person has an address listed other than the address at which that person listed when that person registered to vote. So the person moved, whatever, they don't live at the same place as when they registered to vote. That's one part of the statute, no dispute about that. We have problems though when we get to the petition state form itself, because it states that the person is to sign this out and must, don't worry about what precinct you're in or location like that, wanting to make sure that the person is registered to vote. So it's their address, that's what they're supposed to list. Then we have another statute, and that is a statute that follows the statute on you must state where, it's 3-8-6-6 that states, well, you have to, the person accepting the petitions can only certify those signatures if those signatures list the address of the person signing the petition as of the date the person signed the petition. We have a catch-22, and catch-22 was you could get out of combat in the war if you petitioned saying you were insane and you were afraid for your own personal life. But if you did that and showed concern for your own personal life, you weren't insane. Here we have 2 provisions that are mutually contradictory. The main thing being that no one's disputing these people are legally registered to vote. That's the overarching important thing that we have in this state on these requirements, is to make sure that the person is registered to vote in Marion County. There's no dispute that something like 1,100 of these signatures were people registered to vote, and yet their signatures weren't counted. And if you look at the case that I cited, Brown versus, I lived in Chicago at one time, I think it's pronounced Griscoviak, from 1951, it states, if we have something that's just a technicality on keeping someone from voting, then look at what the true reason is for having the statute. Here, we have means by which you can check and see if these people were registered to vote. They were. It says that they just weren't at that same address. We have instructions saying that they have to put down the current address where they live. When I sign something, I'm a lawyer, but I'm kind of careful. If I'm signing a state document, I want to make sure that I'm putting the accurate information that's on there. If I have any doubts, I'm going to be hesitant to do that. That's called the chilling effect. We shouldn't do that when it comes to voting. Now, there are other means by which these voters' legitimate registration can be checked. There's date of birth. The people's names are on here. Those are important considerations, and it's arbitrary or capricious to remove them. It's just something that doesn't meet what a reasonable person otherwise would do. We have one person who's homeless. He has a right to vote. He has a right to have his signature considered here. But he was discounted because he did not have an address, but he was registered to vote. We have people who printed instead of providing a signed cursive signature of their name. I don't get millennials, okay. I tried to adapt when I was a young person. I thought I was hip. But people today are printing their name, and that's their signature. Indiana law for decades has said is even if you put an X for your signature, that counts, if that was your intent. There were errors on registered voters who actually were registered but were counted as not, and people with ditto marks weren't counted because they used ditto marks. And the sheet that I received last night at 8 o'clock, I appreciate, I think, was it Ms. Delaney that sent it to me? It says on the second page here on helpful tips to remember, and this is guiding. It says, we accept ditto marks.
Mr. Small, that's time. We'll ask the board at this time if they'd like to grant you additional time.
I'll wrap up in 2 minutes. I appreciate that. Thank you very much. All of these are indicators that we have contradictions on what the instructions are. The people whose signatures weren't counted are registered to vote. There's no dispute about that. To strictly adhere to the statute that's contradictory is to leave these people out in the cold. What's the downside? We have a candidate who's put on the ballot that people can vote for or not. The surest test of truth is acceptance in the marketplace of ideas. That was something I learned a long time ago in constitutional law. The surest test of whether a person should be voted for is if they're on the ballot. This took a lot of work. You guys see this every day when you're in here listening to things. You know how much work this takes and how much work you guys do. They met the test, and to not let these people, a lot of them probably won't vote for John Schmitz, or maybe they will. But you're not letting their voices be heard, and we would ask that all those categories be recognized as being arbitrary and capricious, and that Mr. Schmitz be allowed on the ballot.
Are there any questions for Mr. Small about members of the board?
I have a question. How many, based on the categories you identified, how many how many signatures were denied in each category? Do you have that breakout?
I believe it's 1,100 on the RDAs, in other words, registered but different address. It was, hold on, something like 27 had printed signatures instead of cursive. There were, I believe, 60 mistakes of people who were registered but were counted as not registered. No individual category is sufficient to meet the 751 voter threshold that I understand he was determined to be short of, nor added together do they meet that 751. It's the one category of the NDA. But I believe each of those lends itself to an interpretation of arbitrary or capricious nature of the rules.
I'm gonna ask a question of the Director of Council. We've had 2 reviews, is that correct? And so that's when you're referencing the 55 ballots and some clarification on that, inching closer to the number. I just want to make sure, can you explain that?
I'm not sure if he's aware of that, and I think we should defer to voter registration to talk about the process that they've used to review the petitions and any subsequent review.
Okay.
Yeah.
Are there any other questions?
That was the same question I had. That was the only question I had.
I have one other question regarding your argument that the location that's listed on the petition, the fact that it doesn't match the voter registration, you're saying we should ignore that that's an irrelevant term. Did I understand that correctly?
That's correct, for 2 reasons. One is the state form itself says, write down where you currently reside. And another is not the next section of the statute, but the section after that of the statute says that the person accepting the petitions has to certify that each person signing the petition signed with the address at which they currently reside at the time they signed the petition. So those are contradictory.
I'm not sure who this question will be for, but isn't there a requirement that you update your voter registration within a period of time after you change of address?
No.
You can vote anywhere now.
And you can have a license for 6 months, 6
Yeah.
years.
I don't know whether you can't vote. It's like the voting, the date and timelines have to do with the election day and when you moved. And and where you're registered to vote, but I think you have an unlimited amount of time to update your registered to vote, you just may not be able to vote.
May not be registered to vote. I
Probably, yeah.
Okay, thank you.
Yeah.
I'm sorry, I caused any additional confusion.
No, that's okay, but I believe that's correct. So each of these people, as we contend, was registered to vote validly on the date that they signed.
Absolutely.
But not to belabor the point, isn't there a reasonable argument that if they put down an address, notwithstanding the fact we're talking about a county government, position, if there was a district that was dependent upon the specific address, allowing you to vote in or out of that district or get on or off the ballot as a result of that, wouldn't it be unfair to allow someone who is registered within it or without a district to sign a petition to get somebody on the ballot?
I don't believe that there's any allegation that anybody did live outside the county. It was that they had a different address.
Within the
But-
county,
district.
within the county.
You're talking about the spillover effect. I think
Yes.
Director Finch is saying the spillover effect, if you actually have district races themselves, this is a countywide race, but what does this set up for presidents going forward as well?
Gotcha.
If we're District 5, I'm just throwing something out there, you registered in District 5 originally, but you live outside, vice versa, signed the form, are we setting up the presidents going forward?
Yeah, and three ways I'm gonna answer that. I'm not trying to sound like my attorney thing, but one, that's not the case here. Two, if that is something that's a problem that needs to be addressed by the General Assembly.
Yep.
And three, if that is a problem, I guess just two instead of three.
Well, to your point, Mr. Small, maybe we would just ask this question. We said point two, this needs to be addressed by the General Assembly. If there is some contradiction currently in state law, isn't that the appropriate place to change some of these matters down the road as well?
Not for my client, because if we have something that is arbitrary or capricious and that prevents my client from being on the ballot, then that's a matter that should be addressed now. If there are problems with the statute, then the General Assembly should deal with it. And if they say, yeah, we've got a contradictory statute here, we need to deal with it, let them. But this happens sometimes. They don't draft statutes right, and nobody, to the best of my knowledge, has looked at this contradiction here. We have, and it's preventing my client from being on the ballot, and to the extent that it does that, it's arbitrary or capricious.
Well, it's preventing your client from being on the ballot this year, but it's not precluding him in future years, would it?
I think that any time we deal with an election, we have to deal with it as though it's our last election. We have rights that are so deep that if we don't react that way, we might not have a chance for somebody to be on the ballot. And also, my client we're mortals.
He's done
People
work.
might not be around for the next time for the elections next time. And if there's a constitutional infirmity in the way in which this is applied, and it's arbitrary or capricious, then he should be on the ballot now and not just down the road.
Can you clarify, when you're saying that there's a conflict, are you saying two different statutes conflict with each other, or are you saying that there's a statute that conflicts with the CAN 44 form?
I'm saying both. I'm saying both, because if you look at Indiana Code 3-8-6-6A, set A says that the residence address of each petitioner as set forth on the petitioner's voter registration record, okay? Then you come to 3-8-6-8, and that provides for a petition of nomination to be considered valid by the officer required to receive the petition. The county voter registration office in the county where the petitioner is registered must certify that each petitioner is a voter at the residence address listed in the petition at the time the petition is being processed. So that's an inherent contradiction. And then you have the form itself, which says list your address. And this is an official state form. And I know some people would say, well, this is the law, ignorance of the law is no excuse. Actually, it is. If it's something that's malum prohibitum, it's just a technicality and not something that's a deep moral basis for a violation, then ignorance of the law is an excuse. And this is all contradictory that's being put out by the state. So if you're going to err any direction, it should be on allowing the person to be on the ballot.
Are there any further questions for Mr. Small? Thank you, and as we mentioned, there'll be a chance to follow.
Thank you very much.
We'll now call
morning, everyone. I'm going to stand over here so no one has to look at my back. I'm Matt Jaworski, Office of Corporation Counsel, and I represent the Board of Voter Registration here in Marion County. Board members, council, good morning. I'd like to shed some light on the process by which these signatures are received by the office. Candidate goes out, solicits from whomever, want to be on the ballot, I need a signature, here's the form. And so they go out, what is a long process of going out and getting a lot of these signatures put together. Those are then submitted to voter registration. And the staff of voter registration goes through them and either certifies them or rejects them. And in this case, there were 8,295 total submissions to voter registration, 8,295. At the conclusion of their review, which would have taken place after 12 noon on July 1st, 5,458 were certified as acceptable, and another 2,837 were rejected for various reasons. I can go through those in a minute. So the largest category of signatures that were rejected, roughly 1,300 or 1,298, were people that were not registered. So the effort by Schmitz and his team to secure registered voters, I don't know if they had a way with them to ascertain whether or not those people were registered ahead of time, but they submitted roughly 1,300 of them of people who were not registered. The next largest category, as council made mention of, was 1,115, and those are registered at a different address. And you're aware of the argument made by council, but again, the controlling statute 3866, it clearly says the residence of each petitioner as set forth in their voter registration record. That's set out by state law. That is not a local county rule. That's not an election board rule. That's not a voter registration rule. That's a rule set by the state of Indiana by its legislature. I don't believe this board has the authority to ignore that law and say that it's something other than that. Additionally, there were 60 that were not legible, 164 that did not list an address at all, 35 that we categorize as having no signatures. Those are likely the people that printed their name instead of signing their name. I'll return to that category in a moment. 48 were duplicate, meaning that 48 people tried to register or tried to sign a petition twice on Mr. Schmidt's behalf, and then 117 were out of county. So prior to the deadline of July 1st at noon, there had been conversations between Mr. Schmitz and the staff of voter registration in regards to this process and whether or not he was doing it correctly. Understanding there might be some potential for confusion, I in fact telephoned Mr. Schmitz prior to the July 1 deadline and advised him of the proper procedure to make sure that his efforts weren't in vain and how he could capture a better result on registering voters. It is always anticipated that you will have a larger number and distill down to a lower set of number of people for their various reasons. They're not registered, didn't sign, out of county. So you typically have to aim high, and the number which Mr. Schmitz had established was 6,104 registered voters. So understanding this was an ongoing process, the staff dutifully went through the sheets. There were 869 of them all told to be submitted. They reviewed those sheets quickly and notated on the right-hand column, if you have one in front of you, whether or not they were accepted or rejected and the reason why for all of those. That process takes a lot of time, but I even telephoned Mr. Smith to let him know sort of where he was along the way, to have a status of how far he had come, to make sure he understood how many more he needed to get. And so I wanted to make sure that the staff was also poised and ready, that if Mr. Schmitz came in with an armful of sheets, they were ready to process those immediately so there'd be no delay in him giving an accurate count of how many signatures he needed. Now, after July 1, a certification letter was provided, signed by LaDonna Freeman and Cindy Mowry, who are the executive directors, both Republican and Democrat, voter registration, establishing that 5,458 signatures as being proper. That left a shortfall of 749. After being made aware that Mr. Schmitz was challenging the verification process done by Board of Voter Registration, I asked the staff to go through again all 8,295 and reevaluate them. Obviously, the ones that were accepted already did not have to be reconsidered, but the 2,800 that were rejected did. Of the ones that did not have, were illegible, we had a second staff person other than the first person review that to make sure one set of eyes could read it but not another. And additionally, making sure that anyone who is not registered, in fact, we missed it, perhaps their name was Richard and we looked at Rick or Matthew instead of Matt, some other abnormality. We found 55 errors that we believe can be attributed to in a positive manner for Mr. Smith. Additionally, after consulting the Election Commission on the no signature or the printed names, which is a total of 35, we believe it's proper to afford those additional 35 to him as well. And there are additionally 5 others that are under review, which could go to Mr. Schmidt's favor. So all told, if we gave him the additional, he's looking at additional possibly 90, potentially 95 to the good, and he'd still be several hundreds short. The Board of Voter Registration does not set the number required for Mr. Schmidt to achieve. That's not a number we establish, and we do not have control over what is the content of that form.
It's time to ask the board to like grant an
Yes, that's my final point. We don't control the number that's established, and we don't control the content of that form. That form is produced by the state and is disseminated to counties for us to use. That's the only form we have. So, I'll take any questions.
Were all 869 sheets submitted at the same time?
No, ma'am. No, ma'am. It's a rolling process as best I can describe it. The candidate has roughly January to July 1. We call it the sprint, essentially, for them to get out there, meet people, get them to sign on and be a part of it. They're turned in chunks, essentially, so 200, 300, 400 at a time. In which, so it's, and they're all paper, nothing's electronic, so we have to go through by people's individual handwriting to go through them, so it's an intense process, but understanding the importance of it, we dedicate a lot of staff and a lot of staff hours to making sure we go through them as quickly and as efficiently as possible.
You mentioned that the candidate in question was contacted before July 1. Do you have the exact date?
I can go look at my phone records, but I spoke to Mr. Schmitz at least twice in the week prior to that, understanding that I wanted to advise him of what his status was. I believe he was in the low 3,000s at that point of what he had been considered accepted, and I wanted to make sure, understanding that he had roughly a week or so, and I believe the conversation was that he was out at the Marion County Fair trying to get signatures, and that was out there dawn to dusk doing that. So.
And one other, just to clarify, you said you had alerted and prepared staff in the event that more signatures would come in, so we get this taken care of before July 1.
Yes, our biggest concern was that with the clock winding down, there would be pages that were not processed, and so we reallocated staff to make sure that those were gone through immediately, to make sure that if in fact he was going to be short, he'd know how short he is as quickly as we could. Obviously, there was a fair amount that were turned in at the last moment, but we tried along the way to give him a rolling total of where he is along the way.
For the 1,115 signatures that were registered at a different address, were all of those Marion County voters, or some of those out of county?
No, we actually had 2 separate categories. We had an out-of-county category, which 117 people were not eligible, and then the other 1,115 were Marion County who did not match their address.
Gotcha.
Any further questions? Thank you.
Mr. Small, I'll now give you your time for rebuttal.
Thank you very much. I don't have much different things to say. All 1,115 people registered to vote in Marion County. There's no question of that. That means they should have their voices heard. Nothing could be more important than our election process. Everything else is derivative from it. I'm privileged. When this country was founded, white male landowners were the only ones who could vote. We've had a lot of fighting, wars, and everything, people dying to secure the right to vote, for people to be on ballots. 1,115 people weren't counted, even though the instructions on the state form, and Matt didn't disagree with me on that, and didn't disagree with me about the conflict in the statute. In other words, they signed, they're registered voters. And yes, we need to follow the law here, and the law is, according to our case law, we look at making sure a person has the right to vote, and that's the most important thing. If there are contradictions in the statute, then it's arbitrary and capricious. You still have to certify that the person is a registered voter, and I think the purpose of the statute is to make sure that they are registered voters. So you've got an address. For that reason, and also the two categories were counted, and I appreciate that fact that we did count people who just written their names, and that some things weren't so illegible. But otherwise, 1,115 people's signatures should have been counted. That's more than the 654 that I calculated from the 95 corrected off of the 749. It's been a while since I took math. I had a 710 SAT. It didn't do much on my political science degree, but it helped. If there are no other questions, we would ask that Mr. Schmitz be allowed to be on the ballot. Thank you.
We'll open it up for discussion by the board.
Well,
Voter registration, do they have a rebuttal or no? Okay.
Well, I guess that would be the only way we would bring back up other parties, is if there were more further questions.
Clarifying questions for voter registration. Any further discussion?
It's, I guess not really discussion, but I mean, the parties for the most part agree on everything except for the 1,115 signatures, right? And I guess I want to make sure that I'm understanding both sides correctly, right, before we get to any potential decision, right? So the challenger is essentially saying that these 1,115 signatures should be counted because on the CAN 44 form, you have these instructions that conflict with state law, and the state law requires that the person who signs the form uses the address that they're registered at, whereas the form just says list your address. I think that's the crux of the conflict that I'm hearing. I want to make sure that we're all on the same page with that.
I think that is, but that is the current state statutes, and this board and all boards in Indiana have notoriously followed state law, whether we believe there's perceived confliction within state law, and I believe both councils have addressed the fact that that's something that should be looked at by the General Assembly. We are not the Indiana General Assembly here.
Right.
And, I think that's one of the things is that we do have always, at least in my time here, and my understanding from past history, always followed state statute. And so I understand the plight, but that's, the laws are in place for a reason.
I would agree. That's
I agree as well.
my biggest difficulty is that IC 3-8-6-8 is very specific about what the requirements are, notwithstanding the fact that the form may not be as correct. I don't think there's authority within this board to rewrite that law.
I do agree. Private party lies outside of this room.
This is wrong.
With that being said, I'm hearing some general consensus from the board. Is there a motion to accept voter registration's determination?
So, is there any questions or discussion from council?
Is there any clarifying remarks from Director of Council?
Excuse me, does the public get to speak at all here?
They-
Before you all make a decision?
They do not.
Okay.
The time was allotted to the challenger and his representative, and how he would like to use that time in voter registration and their representative.
And what?
And their representative.
So voters are not of importance today. I just wanna make sure that that's clear.
We've had the procedures and policies in place that were outlined at the start of the hearing. This is following other guidelines in the past, and so that's how today's hearing is.
And the board members did not identify themselves, cause I don't see Milo nor Will. So who are these other individuals that are sitting here?
I'll gladly introduce myself for the record. Russell Hollis, proxy for Clerk Milo Eldridge.
And I'm Michael Slater, the chairman of the board.
I'm Paula Finch, proxy for Wilgan.
Brianne Delaney, Director of Elections.
Mindy Westrick, attorney to the board.
David Lichtenberger, Assistant Corporation Counsel.
And members of the public need to be recognized by the chair of this board for further comment. Mr. Chairman, the matter before the board is the candidate challenge, so.
We can't hear you. Thank you.
The matter before the board would be the candidate challenge, so the board should vote on the matter.
With that being said by council, again, we'll go back to the previous motion of, where I would say, I would accept a motion that would accept the determination of voter registration. What's that?
Can you please speak up?
We have a different motion that is being presented.
I move that we deny the challenge, presented on the basis that it is,
Can you speak up?
What?
sorry, I move that we deny the challenge, presented by, Mr. Schmitz on the basis that it is, inconsistent with Indiana law.
Sorry, that was my clarifying, to accept voter registration's recommendation. Is
So
there a
the
second?
form's wrong?
No.
Your
Please-
official
please
form is
restate.
incorrect.
Members of the public, as we remember, please keep comments to yourself.
I'll go ahead and leave, but your document says follow those instructions, and you guys are ignoring them.
It's okay.
Official paperwork.
Could you please restate the
My
motion?
mistake.
I move that I move that the challenge is denied on the basis that, it is not consistent with Indiana law.
Are you an
I
attorney?
couldn't hear you.
Yes, I am.
Could you speak up, please?
Last time, to please speak up, sorry.
I move that we deny the challenge presented by Schmitz.
Is there a second?
I do second. I think there are a lot of bad facts for the challenger, so I do second.